Burrows versus 7525 153rd Street.
Good afternoon. May it please the court. Roger Sacker, Newman Ferrara. We represent the appellants. I'd like to request 5 minutes for rebuttal.
Okay.
This should be fairly straightforward. After the case in the First Department, the legislature enacted a piece of clarifying legislation.
Can they do that?
Absolutely.
I mean, this wasn't a statute, right? This was a common law gloss on a statute that this court decided. And they can clarify a common law rule or a common law gloss on a statute by saying, that's not what you meant?
Absolutely. Well, that is a bigger question of what was meant by Regina footnote 7.
No, but let's assume they're right, which I'm not saying, but just for purposes of this question, can you change that rule by legislative edict later and in this way avoid any type of retroactivity problem?
That's General Motors v. Romaine, United States Supreme Court, which was cited with approval in Regina. There, the Michigan Supreme Court issued a ruling that was contrary to what the legislature thought the intent of the statute was. After that happened, the Michigan legislature said, no, that isn't what the statute is supposed to be.
But I think that's different from what Judge Garcia is asking you. That was a statute, and they were clarifying the meaning of a statute, and here we have a common law rule.
I don't see any distinction here, right? Law is law, right?
Well, no, but the only people who get to clarify that common law rule are the people in front of you.
That's correct, but a legislature can certainly enact a statute that is contrary to common law.
And then we would determine whether or not that statute applies going forward or it's retroactive or not. But it seems this is a way to end run a retroactivity issue.
It may very well be, but there still isn't a problem. The law would, in order for there to be a retroactivity problem, there must be increased consequences for past conduct. And
I'm just talking about the practice of doing this. If we're going to just accept that that was a clarification of a common law rule, then we don't have a new statute, and we would look at a new statute and a change in the law to determine all these things we say you look at. But by clarifying, you avoid that because you're saying that was always the law. That's always what this court meant.
And that's, if you read Thornton, Grimm, and Coniston, that is always what this court meant. It never had a common law fraud standard.
Hypothetically, could they do that?
Absolutely they could. They can say,
clarify what we didn't mean.
if you meant a common law fraud in Regina, they could, and they could apply it retroactively without violating the Constitution.
The only thing they'd be able to do is abrogate the common law. Abrogate the common law. Isn't that the only thing
Yes,
they'd be
they
able
would
to do?
abrogate.
Say, yes, that's what the Court of Appeals said, but we want to come up with a different rule, and we're going to enact it through our legislative powers.
And then we're going to apply it to any
But
case
that
that is
is
pending.
different from saying, this is what the Court of Appeals meant.
Yes, that is different from what the court, they're saying we're enacting this, and then.
And isn't that what they did here? They've made a clarification of our interpretation of the common law.
They made a clarification that your interpretation, if that's what you did in Regina footnote 7, that interpretation was incorrect. That's what they did. But that does not lead to a constitutional problem.
Interpretation of what?
What fraud is meant within the context of the rent regulations.
Well, that's a different question than what common law fraud means, right?
Yeah, well, okay, so the question is whether or not common law fraud is what was meant when the court first used the term fraud in Thornton. It came from a DHCR guidance, hey, in cases of fraud.
Aren't we the only ones who can say what it means, what we meant?
The legislature can certainly, well, yes, you would.
The legislature can say what we meant?
Yes, you would be the ones to say in Regina footnote 7, we meant common law fraud.
Okay, and that could differ from what the legislature thinks. But putting aside whether or not they could, in fact, go through this process to clarify what the Court of Appeals means, I think your other argument was that the clarification, if we're going to call it that, is correct. That the prior case law did not require that all the elements of common law fraud be met. So why don't you
Not until Regina footnote 7. There's no case prior to Regina footnote 7 that said common law fraud. Now,
Do you think footnote 7 represents some sort of sea change from what came before?
Absolutely, 100%. If you look in Thornton, there could never have been reliance.
Okay, so what is the definition and why, in your view, is it the correct definition?
The definition in the legislation, Your Honor, or the definition in
No,
the
set
case
aside the
law?
legislation if you would.
In the case law, it's regulatory fraud. It is and this is the exact
And
quote
why
from
is
Grimm.
that correct as opposed to common law fraud? Why?
Because if you have common law fraud, it becomes almost impossible to show the element of reliance, right? Because if I, as a current tenant coming in, I can't rely on my predecessor's reliance. I would have to show.
So where are other circumstances? I mean, it's a question of legislative intent, right? And so where are there other statutes that use the word fraud or fraudulent and refer to what you call regulatory fraud, which I take it is something shy of all of the elements of common law fraud, as opposed to common law fraud?
Exactly. That's Executive Law 663, subsection 2, and the Martin Act. Both do not require common law fraud, even though they use the word fraud. And in fact, cases.
But those are both, if memory serves me, provisions. I think it's 6312 you're referring to probably. And
6312, I'm sorry, I couldn't read my handwriting.
Right, and the Martin Act, those are provisions, I think, where there's extensive precedent setting forth the elements and how they're understood and so forth. Do we have that in this context?
We don't have very many rent regulatory decisions that talk about fraud. We have the big three, right? Last time I was here, I called them the murderer's row: Thornton, Grimm, and Connaughton. And in each one of those cases, you never had common law fraud. You couldn't have. Because, use Thornton for an example. Cindy Lauper and the landlord are in cahoots to say we're not using this as our primary residence. Well, there's no reliance if everybody is in cahoots together. They weren't relying. They were doing the exact opposite.
Assuming all of that's true, I'm still having a hard time understanding why Regina somehow changes the field. I mean, footnote 7 says what it says, but I'm not sure how it incorporates a common law fraud requirement onto what we had previously been talking about, what a party was required to show for a fraudulent scheme to deregulate.
I don't think it did. I don't think Regina footnote 7 changed.
So let me
the
ask you my
law.
question again. Does Regina represent a sea change in what had come before?
I don't believe so, no.
Okay,
but
because that's the opposite of what you said.
I'm
last
sorry,
time I asked.
I might have misunderstood your question. The First Department thinks so. I don't think so.
Okay.
Sorry, I didn't mean to sidetrack you. And that's the point, right? So the First Department in this case goes, you have to show common law fraud. They start doing this in 2020, late 2022 through 2023. The Second Department has done it in 2021 in a brief passage. But I don't think Regina changed the rules. It's a footnote, and I think if it had.
So if
I'm
that's the case-
understanding your argument. Your argument is if you look at all of the jurisprudence that is making a decision on the merits, where this is a necessary component of the analysis in those cases, the court has considered fraud in a different context in rent regulation, and at a minimum doesn't require reliance. But forget the other elements. We're just dealing with reliance right now.
That's exactly right. And frankly, I think that if the Court of Appeals in Regina had set forth a new standard, I think they would have said it very clearly in the majority, and I think it would have been very clearly addressed in the dissent.
Not in a footnote.
Not in a footnote. Yes, we don't make laws by footnote.
So you think this footnote is just dicta?
No, it could be. There's a number of different ways to look at it. It could be dicta. If you read the entirety of the footnote, the second sentence, which nobody ever talks about, seems to be referencing regulatory fraud. But if it isn't one of those things, you cited 3 cases with approval that didn't have common law fraud and said, hey, we're going to change this. Common law fraud means this.
And the factors could just be factors you consider, not exclusive.
That's how the clarifying legislation puts it.
By the way, was reliance an issue in Regina? Was that a dispute over whether there was reliance?
The only issue of reliance would have been the landlord's reliance on DHCR. That's what people were talking about. That was the main point of Regina, right?
Right. I mean, I view Regina as a dispute about the landlord's intent. I mean, that obviously involved a case about how the landlord went about doing what they did, and at the time they were following what they thought was reliable guidance from DHCR.
Exactly. And the minute DHCR was corrected by this court in Roberts, they went and re-registered.
So that to me means what we're really discussing is was there intent to engage in a fraudulent scheme or was there not intent?
Right. And don't forget, that's what the clarifying legislation does too. It says we're going to assess owner's knowledge to see if and when you assess it, you look at all the law, all this stuff, to see if it indicates owner's knowledge as a way of circumventing rent regulation.
Chief, can I just ask, can you address the rent concession and the preferential rent quickly first, please?
Yeah, absolutely. So in 2019, the legislature passes HSTPA. And as part of that, it eliminates preferential rents. The question is whether or not a landlord has to account for a concession when now under HSTPA or when it registers apartments for the first time in a 421A building. So this language from the code is the amount charged and paid. In our view, and you look at landlord advertisements, they're using concessions to circumvent this preferential rent bar.
Why not follow Fact Sheet 40?
Fact Sheet 40 doesn't say you can't pull concessions. First off, Fact Sheet 40 was superseded after HSTPA.
Okay, but so that question specifically, your view is that Fact Sheet 40 we can't look to because it was superseded?
No, well, that's one of the points. The second point is look at it and read it, and where does it say in there you can pull one-time rent concessions? It doesn't. It says a amortized rent is a preferential rent and will be treated as such. And it differentiates that from one-time rent concessions, but it doesn't tell you what you're supposed to do. And the only point the court below made with respect to this was to say, well, we assume the legislature knew about Fact Sheet 40. But that when it passed HSTPA, but this court has held that that's the most dubious of arguments when you're interpreting legislative intent. Thank you.
Thank you.
May it please the court, Daniel Maggi from the New York State Attorney General's Office on behalf of the state of New York, amicus curiae in support of appellants. The appellate division's decision that tenants must show reasonable reliance to invoke the fraud exception fundamentally misapplies this court's cases, as my colleague mentioned, and it also violates the driving purpose behind the fraud exception, which is to protect the public and the rent regulation system, not just the individual tenant bringing an action.
So do we need to address in our determination, our resolution, the quote-unquote clarifying legislation? Is that relevant really at all to the case?
You don't have to address that. You could say that the appellate division erred in requiring reasonable reliance and remand it to the appellate division to consider any unanswered questions in the first instance. If the court chose to address the clarifying legislation, as we argue in our brief, you should find that it's not retroactive, then that it applies to pending actions like this one, and that even if it is retroactive, it satisfies due process and the legislature intended it to do so. There is some concern. I heard questions about whether the legislature can do this. Can it clarify what Your Honor said in prior cases? And the answer to that question is yes, and I would maybe like to pivot sort of the thinking about it. It's not the legislature saying this is what the court meant, or this is what you meant in Regina or Thornton prior cases. It's saying that the interpretation that this court, in this court's decisions, that followed the legislature's intent. But what happened is Burrows, the first department's decision in this case, was like an aberrational decision that no longer follows the legislature's intent, and therefore the legislature...
Why is that not just a straightforward legislative override? It happens from time to time where a court reads a statute, interprets it in a particular way, and the legislature wants some different policy, and it overrides the court decision and enacts a different statutory provision. I don't really understand what clarifying legislation is that is distinct from an override, but maybe you can illuminate that.
The way you just described it is exactly what happened, and maybe the...
So if what the legislature's doing then is it's saying, you know, the court, the first department decision suggests X, the rule is Y, then don't we go through the retroactivity analysis as we would with respect to any other newly enacted statute?
Yes, the court would go through that analysis. Our position here is, though, on that first step, whether it is retroactive,
Yes.
the answer is
and
no.
Why is that?
It is not retroactive because it doesn't change the prior law in the sense of the consistent history of this court's decisions from Thornton on and the interpretation of the look-back rule under the prior before the HSTPA.
But if that's right, we don't have to get to the statute at all.
Right.
And as I said, you don't have to get to the statute. If this court remands, though, says the first department was wrong to require reasonable reliance and remands, then the first department, though, may have to address that question whether what we are calling the clarifying legislation applies and whether the plaintiffs have met that standard, because we do argue that it applies to pending actions like this one. This court doesn't have to address that question, but at some point in this litigation, that question would have to be answered. So to answer your
In
question.
this litigation, it would have to be answered? If our holding was, that the appellate division erred in imposing a reliance requirement and they should go back and reconsider it, because that's what our law has always been through Thornton and all the other cases, why would the legislation arise in this litigation?
Because the legislation applies to any action pending, or it doesn't say that
But how would there
pending,
be
but-
an open question then
Well,
that
we
the
yeah.
legislation would be relevant to?
We resolve it based on our common law, based on our case law, which, under your version of our holding, says we never imposed a common law fraud requirement or a reliance element requirement. So the question of whether the legislation fixed anything becomes moot, doesn't it?
Sure, and perhaps the answer is that the legislation applies, but we don't have to do any further analysis because they met the standard that this court has set, and that's perfectly fine. I was just saying, in other actions, there is this legislation, and it applies in any action in any court, and so the analysis goes under that statute
So if we
now.
agree that this is what we meant, which is just, it's hypothetically, essentially the same as this clarifying legislation, it's moot. Really? What effect does it have? We're saying the same thing, right? If we say our rule was different, then it's new legislation. Then it's changed the rule, so it doesn't clarify anything, it's new. So I don't see how it can really be clarifying in any way. Either we meant that, in which case, no harm, no foul, and everything's kind of the same, or we didn't mean that, we had a different rule, and now you've changed the rule, and we could accept that as a new statute.
Sure, so one, I think there may be just an issue with the use of the word clarifying legislation as a
You
shorthand.
don't know of another time we've gotten clarifying legislation of this kind?
I don't view this as being different from really any of the other normal circumstances where there's a statute, there's an interpretation of the statute, and the legislature then amends the statute
But is
in
our,
response.
is our discussion of fraud in the rent regulation context an interpretation of the statute?
I believe it is, because if you
What
read
statute?
the look-back rule, because Thornton says, this is the look-back rule, but we are going to find this fraud exception because the legislature could not have intended for the look-back rule to apply to cases like
But
this.
you agree it's not expressed in the legislation?
It's not
It's a
expressed in-
carve-out that the court identified, an exception to give
Correct.
meaning to the legislation.
Correct. But it's still an interpretation of that legislation to say that that law does not apply to circumstances like these. And the legislature, as the court continued to follow that rule, didn't see any reason to enact legislation because it agreed with what this court had done.
But you might say, let's say I went with that. You might say that the way the court thought about fraud in the context, though, is not necessarily so obvious that that was the legislative intent. Yes or no?
I'm not sure I understand the
The
question.
way, let's assume for one moment that the court agrees that all of the elements of common law fraud are not required in the rent regulation context. And that's really what the court had decided in those cases,
Yeah.
right? That doesn't necessarily flow from trying to give, what you're saying, trying to give real meaning to the legislation.
But it still is an interpretation of that legislation. When one of the litigants says, this is a statute of limitations that requires
Well, it could
for-
be interpretation of the statute to say, well, it couldn't possibly have meant that an owner that commits fraud gets a
Correct.
benefit.
Sure.
But the court could then say, and this is how we would, right,
Understood.
define fraud for these purposes.
Absolutely, that is possible. But what happened here is consistently, over years and years, this court had interpreted fraud the exact same way, never requiring reasonable
Well, yes,
reliance.
but that goes to that stare decisis,
Sure.
and whether or not you can really call this clarifying legislation,
And-
or at least in part.
And let me just try to answer Judge Garcia's question
Well,
as to
before-
whether
I'm
this...
sorry, I'm not trying to cut off Judge Garcia's question, but just to clarify, apart from this issue about whether or not the legislature could pass, quote-unquote, clarifying legislation of a common law rule, isn't there some issue about whether or not the fraudulent scheme, as defined in that legislation, is different from what we have said in the past, even if we agreed that, as Judge Garcia has said, you know, whatever they said about the elements of fraud, it aligns with what this court intended, so it's almost irrelevant.
So, yes, that would be an issue. Our position, though, is that it isn't a change from what this court had said for years
So
and
the
years.
same as in the question of fraud.
Exactly. But just to answer Judge Garcia's question as to whether, if this is a change, then what happens if the court disagrees and says, no, we did require reasonable reliance or common law fraud, the answer is that maybe that makes the clarifying legislation retroactive, but that's just step one. And you still have to go to legislative intent,
Wouldn't
you
get
still have to go to due
around the-
process.
I'm sorry, it wouldn't get you around the retroactivity analysis, it would begin the retroactivity.
Correct. You just say, okay, you know, our position is it's not retroactive, but let's assume that it is. Then you go to legislative intent. You have that here. It clearly applies to pending action, so it must apply retroactively. 2, it's rational for the legislature to say that the court has, misinterpreted the look-back rule. The Burrows court did to require reasonable reliance. That does not protect tenants. That does not protect the system. The whole point is to penalize fraud. And the legislature thinks requiring reasonable reliance does not do that. Therefore, it satisfies due process. So even if it's a change in the law, it doesn't make the clarifying legislation unconstitutional in any way. And that, just to almost circle back, you don't have to address that question at all in this case, but if you do, you get to the same point, that the tenants have met their burden, at least at a motion to dismiss, to satisfy the elements of a fraudulent scheme. There's a misrepresentation here. There's at least indicia of knowledge because they did this for every apartment in the building. The law is clear as that this was illegal. And you also have a scheme here in the sense that this is hurting tenants and they're gaining an advantage to the landlord, allowing them to set a legal rent that is well higher than what they were permitted to do and reserve the right for any new tenants to come in to charge them thousands of dollars more than they should have been entitled to.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Deborah Riegel from the law firm of Rosenberg and Estes for the landlord respondent. I understand why Appellant's counsel wants to focus on Regina, because I feel like I have been debating what footnote 7 means since the day the decision came down. But we are not here to relitigate Regina. We are here on an order of the appellate division that found unequivocally, whether you base it on reliance or some other basis, they found unequivocally there was no fraudulent scheme here. And
And
this,
why is that? Why is there no fraudulent scheme?
And-
Of course, the appellate division did decide that Regina required reliance, but we'll put that to the side for a moment.
So why is there no fraudulent scheme here? This case is almost identical to the Reich component of Regina. This is a case where this landlord incorrectly, but openly and truthfully registered rents from the very
Well,
day.
unlike, well, not like Regina, because you don't have the DHCR saying, yes, that's exactly correct. What you've done is lawful.
No, but from a disclosure standpoint, Your Honor, every year from the very inception of this, of the
Is that about
tenancies.
reliance? Is your point there that?
No,
they
my
rely-
point
okay.
is that there was a statute of limitations in place until the enactment of the HSTPA. And none of us dispute that pre-HSTPA law applies here. So there was a statute of limitations. That statute of limitations, which is sometimes conflated with the look-back rule, but prior RSL 26516A1 said, where the amount of rent set forth in the annual rent registration statement filed 4 years prior to the most recent rent registration statement is not challenged within 4 years of its filing, neither such rent nor service of any registration shall be subject to challenge at any time thereafter. These registrations were filed in 2007. They bring this case in 2020. 13 years later, 2 owners later, after my client bought the building, based on registrations that were filed and that were public record, based on the fact that the statute of limitations had expired, and based on the fact that no challenge had been brought. So what they are arguing is my client should have had a crystal ball on a number of bases, and when we get to Waller, we'll talk about that as well. My client should have had a crystal ball to know that what was proper and final under the law as it existed might somehow no longer be final.
Well, when you're saying proper, what was filed unilaterally. It's what the landlord says it was. If it's not challenged, you don't know if it was accurate or not, but if it's not challenged, it's not challenged. But doesn't necessarily mean what you're arguing now.
Well, when I say proper, I mean it had, by virtue of the passage of time and the expiration of the statute of limitations, those rents, and I understand the argument that you can't.
They went unchallenged.
They were not challenged.
And so are you really arguing it's really unfair? They went on for a number of years unchallenged, and now, after all of that passage of time, your client is disadvantaged?
Well, I do think there's an equitable piece of this here, but there's also this is a statute of
But
limitations.
if that's the case, why would you ever employ the fraud exception? Maybe I'm missing something here. I mean, that Thornton, Grimm, they all are older cases. Why wasn't the answer in those cases it's a 4-year statute of limitations? Sorry.
Because they were timely brought. And there
They
was
were brought
fraud.
with
I'm
it-
sorry, they were either timely brought or there was an actual fraud. And to compare
Well,
what happened.
okay, I want to understand the distinction there, because isn't the question here in part what the standard for fraud is? I mean, if it's permissible to proceed if there's fraud, even if it's not brought within the 4-year statute of limitations, I take it you're saying that's permissible, and then the question is, what are the elements of fraud that are required? Is that fair?
I think it's fair, but I don't think, again, the focus on footnote 7, I think, distracts from the fact that whatever definition of fraud this court or the appellate division wants to apply, the hallmark of fraud is an intent to hide and deceive. Nothing was hidden here.
So essentially, what you're saying is that there are no indicia of fraud anywhere here.
There is no indicia of fraud. The only thing that counsel points to as his indicia of fraud are the publicly filed rent registrations, which were known and available.
And to which, in the lower court, in Supreme Court, your response to that was, yes, but you have to show reliance. So it sounds to me like you're making a different argument here than the one that you were making in Supreme Court. Now you're just saying there's no evidence of fraud anywhere. But that's not what you put forth below.
I think what we put forth below is that there was no fraud because these were openly disclosed and they were available.
So you
and-
couldn't rely on them, I thought was the argument from that, though. So
Well-
no one could rely on that because the information was known.
In addition to the fact that the information was all known and the claims should have been brought within the statute of limitations period, you can't get to the fraud exception because you knew all of this.
But
And
how
what-
do you square that, though, with our prior decision in Thornton, where they clearly knew?
So I think to compare what happened here to what happened in Thornton in determining fraud, The facts in Thornton are egregious. There was an actual intent to deceive in Thornton. You had a landlord and a tenant who conspired to take an apartment out of rent
Who's being
stabilization.
deceived?
Excuse me?
Who's being deceived? What's the intent to deceive?
The-
Everybody knows. If they're co-conspirators, where's the deceit?
The scheme in Thornton was that the landlord was renting to Thornton, who would then potentially have the right to sublet that apartment. And so there was an intent to deceive, and there was an intent to defraud. And whether I agree, and I quarrel a little bit with a private plaintiff bringing a case in order to vindicate rent stabilization, I think Thornton, you got to where you got on Thornton because the facts were so egregious. That is not present here. What you have here.
If I'm understanding your argument, you're sort of saying, okay, owner's not telling the truth, but as long as they were loud and proud about it, you can't bring an action.
But this owner was telling the truth. They believed, because it's consistent with their leases, they registered rents that were consistent with their leases. They made a mistake.
But they had legal regulated rent and actual rent being paid, so that wasn't allowed.
It wasn't allowed, but it wasn't fraudulent. They
Well,
didn't.
what's the distinction between the two? And, I mean, well,
And
maybe start with that. I have a follow-up question.
Dismiss?
Well, so the distinction between the two, I think, is any intent to deceive the tenant. They gave the tenants leases that said there were preferential and legal rents. Incorrect? Yes, incorrect. Fraudulent, fraud has to mean something more than making.
How do we know?
I'm sorry.
Go ahead.
Did they base subsequent rents on the higher rent level, not the preferential rent?
No, not for these plaintiffs.
But they could have.
But that's not in this record.
So it's your position that from the initial rents that were being set, that there was no increases that weren't authorized?
Not only-
By, regular rent
Based on the
increases,
lower
based-
number?
All of the increases for all of the increases for the apartments these plaintiffs occupy were taken off of the lower number. And in fact, there is no real dispute that the increases were based on the lower number.
When you say the lower
Is this
num-
on a motion to dismiss, or am I
It is on a motion to
misunderstanding the
dismiss,
posture?
yes.
Okay, so how do we know all of these facts?
Because we have documentary evidence. We have the registrations and we have the leases. And in fact,
So you're saying, your position is that as a matter of law, no matter what exactly the standard for fraud is that we would settle on, it can't be met?
yes, because there's no deception. Because for two reasons. One,
Why doesn't that go, I thought, I think Judge Cantaro said this, I thought below that went to reliance in your view, not broadly to whether there was fraud here or not, or misrepresentation.
I believe, and obviously you and Judge Cantaro may read our arguments differently.
Understood.
I believe that the argument below is that there was not fraud, in part because you couldn't rely, in part because this was fully disclosed to these tenants, in part because there was a distinct statute of limitations that specifically said, if you have registrations, those registrations have to be challenged within 4 years, or the rent is forever enshrined.
But did you
And-
make this argument, which I'm hearing now, that it wasn't fraud because we never used anything but the preferential rents to base increases on?
Yes, and in fact, counsel responded to it, and the response was not that there were increases that exceeded the permissible increases for his plaintiffs. What his argument is that, well, there were vacancy allowances at points along the way, and how do we know whether those vacancy allowances were proper? Well, if it's a fraud claim, they're required to plead specifically what the fraud is. It's not, maybe there was something that doesn't smell right. And that's the only thing they point to. They do not say, in fact, They concede that when we reconstructed the rents and showed the court that there were no improper increases, they concede in their brief that those increases for the plaintiffs were proper.
And it's
I'm
not
sorry.
enough for plaintiff to say, we have our initial rent registrations that don't comply to, at least for purposes of surviving a motion to dismiss?
Not 4 years later when that information was available to them, because then what you're saying, I think, is there's a different standard for these plaintiffs' compliance with the statute of limitations and for knowledge of the law and for compliance with the law than there is for a landlord, because they have the same constructive knowledge of the statute of limitations that we do.
Well, what I'm saying is, what's the bare minimum for demonstrating a fraudulent scheme of some sort?
Some deception. And there was no deception here because.
So now it's about intent. So now it sounds like you've changed the tenor of the argument from reliance to intent. As long as even if the initial rent registration was incorrect, improper, if there was no intent to deceive when it was done, then it's okay.
I suppose at its base, what I'm saying is the only thing they have argued here, which this court and the lower courts have consistently said is not sufficient, the only thing they have pointed to here is an alleged illegality in the rent. And this court and the appellate divisions have said you can't just say the rent was improper. There has to be something more.
That's just a rent overcharge, is what you're saying.
Correct. And if that is the standard that this court adopts, that any mistake in a rent registration is indicia of fraud, well, then the exceptions now swallow the rule.
They're not claiming like one little mistake, right? I mean, I thought their argument was there's a full-blown pattern, and that in part gives you some of that indicia.
Well, they are alleging one mistake. They're alleging the same mistake for all of the
same
apartments.
type of mistake, the same class of mistake repeated over and over. But let me, I just want to clarify this other point you're making about, or understand it for myself, about the rent increases. Am I understanding this argument as sort of a rent creep argument? That yes, there's a number that would be permissible, and if we had gone above that number, yes, that would have been a violation of the law. But since we didn't go above that, we got closer, perhaps the number should, by law, been a little bit lower, that somehow we haven't violated the law?
No, what I'm saying is there was no overcharge here. There is simply purely no overcharge
Well,
here.
even if there's no overcharge, if the numbers are incorrect, why is that not a violation of rent regulation law? Because the point is you're trying to get these accurate numbers for fear that down the line, you are going to end up with an apartment that no longer is fully regulated.
Well, because I'm addressing the complaint as they pleaded it, and their complaint as pleaded seeks damages for rent overcharge, and there are no overcharges. Pure and simple, at its very
Isn't
base,
that a
there are no
damages
overcharges.
That may be a damages issue, but let me just ask you this. Let's say the preferential rent was 1,000 and the legal rent is 2,000. So it should have been registered at 2, but it's registered at 1, and it's disclosed.
Mm-hmm.
Under what happened here, you're saying that the rent that these plaintiffs were charged is not an overcharge based on what you could have increased that $1,000 figure at over that period of time under the law.
Correct. There was simply no overcharge. And, I think this.
But isn't the result of that you continue to have the wrong numbers? And that's the violation?
Having wrong numbers is different than having fraudulent numbers, though. And I think this
But
goes back
it's a
to.
motion to dismiss. Maybe later on, you're going to be able to persuade whoever decides that issue that there was no fraud, or as you say, no intent to defraud.
I think that there are fraud questions that are susceptible to determination on a motion to dismiss. Look, I think every time one of us gets a complaint, we think about whether we can meet the standard on a motion to dismiss. And obviously, I thought in this case that we could. And I think this goes to what Chief Judge Wilson said in the dissent in Regina, which is that the maintain or produce provision of the law, which also is implicated here because as a subsequent purchaser, my client doesn't have records, if we go back to Supreme Court, is meant to protect landlords who do file timely but incorrect registration statements, statements that show an illegal rent for an apartment that the landlord still considers regulated. That's what happened here. These are incorrect registrations. I can't hide from that. These are incorrect registrations, timely filed, with no records should this case go back because we are 20 years down the road. That's exactly the purpose of a statute of limitations.
How do we know from the record before us? You said there's documentary evidence, that this is what you call, I'm not sure I understand the distinction between a wrong number and a fraudulent number. I assume it has to do with C-enter, but you tell me. How do we know that on this record specifically? How does the record, what is the documentary evidence that establishes what I take your position is, which is there's no C-enter and therefore it's wrong but not fraudulent?
I think what tells you that is that the increases comported with my client's obligation, the prior owner, and then my client's obligation under the law to only increase those rents consistent, to only increase the preferential rents consistent with rent guidelines. If my client was trying to defraud the plaintiffs, that might be a different result.
But how, you're saying defraud the plaintiffs. Let's say in my hypothetical, we had 1,000 preferential, 2,000 was the legal rent. Now, with the increases you've been entitled to on the 1,000, the rent's 3,000, you could charge, let's say, 6,000 using the other figure. They move out, can you charge the new tenant $6,000 if we say this is okay?
I'm sorry, I want to make sure. So
1,000 is registered as the rent, but really the market rent is 2. You're saying over this period of time, you were only using the increases to the $1,000 preferential, so there are no overcharges. At this point in time, let's say that gives you a $3,000 rent. If you had used the original figure, it would be $6,000 with the increases.
Right.
Tenant leaves, can you charge the next tenant $6,000?
Do you get the benefit of your registration?
no, and they didn't take the benefit of the registration.
Why not?
And the record
Why
reflects
can't
that.
you charge the 6?
Because you're saying you can't look back, so now it's 6,000, that was the rent, that was the fair market rent. Isn't that a fraud? If it's true.
But it's not, and it's clear on the record that it's not true. I understand the hypothetical.
Wait a minute, what's the clear on the record that it's not true?
We know, but none of the rents were increased from the preferential rent. No, there was no jump up to the
No, but
legal rent.
that was the hypothetical. That was the hypothetical.
Let's say the plan is to do that. Why isn't that a fraudulent
And then you
scheme?
finally reach that tenant where you want to charge the 6, and they're willing to pay the 6.
But then they'd have a right to challenge at that point. If the rent jumped, let's say,
Isn't that a damages issue? Because if what you say is true, and then you go back and now, okay, look, you haven't been overcharged, there's no damages here.
I don't know that the court below was constrained to allow the case to continue if it concluded that there was a statute of limitations that had expired and there was no fraud. Having reached that conclusion, I don't know that the court is constrained to allow the case to continue through discovery just to get to the point where there are no
We're
damages.
switching horses here a little bit, but I'm saying there could be an intent to defraud. We're saying it just hasn't matured enough yet to give damages. That's, I think, the hypothetical, right? Okay, these tenants haven't been affected yet, but the next occupancy, you're going to charge, let's say, $6,000, and that would be based on these. And then you're saying they could come in and do that, but that seems to me it's the same scheme. It just hasn't ripened yet. You're saying there's just no damages
But
yet.
it's not a scheme, but again, not a scheme to deregulate. This has to be a scheme to deregulate,
that's a
not an
different issue.
not an
That-
overcharge scheme.
That's a different issue about whether or not deregulation means you completely remove that unit from the regulated stock, or you simply set up a scheme by which you're not in full compliance of the regulatory requirements. The most pertinent one, and the one for most tenants that they're really going to care about, is the amount that they have to pay.
So I think that while I disagree with counsel about the application of the new law, I think if you look to the new law, you have the clearest indication, at least of what the legislature believes a fraudulent scheme to deregulate is, because the initial draft of that bill included specific language about a scheme to overcharge. That language was removed from the final law.
But that's
So-
what I'm saying. You could have a scheme to slowly creep it up and eventually perhaps get to Judge Garcia's hypothetical, right?
You could, except in this
Because it's about the numbers. I mean, the point of rent regulation, of course, is you want to maintain this affordable housing stock. What does it mean to be affordable? That the rent has to be in a particular range. That's the whole ballgame.
You could, but in the context of this building,
Yes.
these apartments were always going to deregulate at a point in time because it was a 421A building. This isn't what I'll call, a historic rent stabilized building where by virtue of the HSTPA, no units were ever going to be deregulated. We didn't need a scheme to deregulate the units because eventually they were all coming
But
out.
you may want a scheme to get you a particular amount of money before you get to the deregulation.
I understand your point, but I would say that's not a fraudulent scheme to deregulate.
And if
One-
we disagree with you,
I'm sorry?
and if we disagree with you, are we done?
Won't be the first time.
One question about the rent concession, if I can.
Sure.
So you point us to fact sheet 40, which distinguishes between concessions for specific months and prorated concessions, right? And it looks to me that the lease rider, it's in very small print, but I think it says that there's 2 free months, but it's not specified. So why isn't that effectively a prorated scheme as opposed to one for, say, August, September?
So I first want to point out that, in my view, this court doesn't have jurisdiction to even reach the concession argument. It was not raised in the motion for leave to appeal.
I understand that, but if we were to reach it,
If you were to reach it, I don't think that any of the jurisprudence requires that the rider specifically say, we're giving you a 2-month concession for August and September, or May and June.
so specific months just means a number of
A
months, not
distinct-
any
yes.
actually specified months?
A distinct number of months as distinguished from an amortized rent reduction over the course of the lease. So the distinction being you're getting May and June free as opposed to we're reducing your rent for the entirety of the lease from $3,500 to $3,300. It's an amortization as opposed to a discrete set of
Months.
months.
Although it further says that if you don't fulfill the terms, that the free months shall be deemed null and void, and I take it that means that if you attempted to terminate the lease before the end, you would try to recoup those 2 months of free rent. So it seems to me like it could be viewed as prorating.
I still don't think that would be prorating. I think that's a contractual agreement that, we're going to give you this concession so long as you comply with the terms of your lease. It's still a distinct concession, the brief, appellant's brief spends a lot of time talking about needing to have a reason or not having a reason. The case law does not speak to and nor does fact sheet 40 speak to a requirement for having a reason. And the most benign example of a reason is in Century Operating, which was, we're giving you a concession based on the economic market. Is that a reason? Are we now going to say that if that's the reason you put in your riders, that you can look to see if the economic conditions really were sufficient to justify the concession? And the last point I want to make, because I know my light.
Yeah, and I have a question for you too, but go ahead. Make your last point.
The other point about this concession argument is they spill a lot of ink about this, again, being a scheme and an attempt to evade the restriction on revoking preferential rents. And this is when I spoke about a crystal ball. This concession was given 2 years before the statute changed to prevent revocation of preferential rents. So to suggest that my client was trying to evade a law 2 years before it existed, and on that basis, this court should find that there should be a net effective rent, I think is a monstrous stretch and certainly not supported by anything in the record.
So I'm struggling with an answer you gave, or I think you gave, in response to part of Judge Garcia's hypothetical, where there's a $3,000, the 1,000 is increased to 3, the 3 is increased to 6, the tenant leaves, and he asked then, could you charge the 6,000? And I thought your answer was, at that point, the new tenant could sue.
If, I believe
Yeah,
that hypothetically,
yeah,
if in 2020,
yeah.
the rent jumped from $3,000 to $6,000,
Right, and 6 was what would have been
That-
allowed using the higher figure, yeah,
that jump
yeah.
is susceptible to challenge.
How?
No- Because that tenant has a claim based on registrations, there would be a registration statement in 2020, right, that would show a jump from $3,000 to $6,000. I don't think you could go backwards to the 2007 registrations and argue all the way back to 2007, but I think you'd have a discrete claim starting with that registration and that jump in the rent.
So that your allowable rent, if the prior rent had been 3,000, and let's say your allowable increase was 2%, you'd be stuck with that 2%. You couldn't go up to the 6,000. Is that what you're saying?
Well, I think it depends at what point in time in the legislative scheme we're talking about. Could there have been a vacancy allowance? You know, so I think it would depend on, but I think if you took more than what was permissible,
Based on the prior year's rent and whatever allowances were permitted.
But the point is, it has nothing to do with the incorrect initial registration. It's just based on a
Has
cap
to
on
do
how
with
much
the-
you
right, it has to do
can
with
charge on a vacancy.
yes, it has to do with that discrete
But
set of
if the
conduct.
original if the 3,000 at that point is a preferential rent, why couldn't you increase it to 6? Because that would be your argument, right? You know, we were charging you 3,000, but that's a preferential rent, so now you're getting charged what you should be. You can't go back any further. That's the market rent, so it's a jump, but we can do it.
I suppose, I suppose you could. I would expect a challenge on that.
And could they go back and look at the old rent statements then?
I don't think so because the statute of limitations had run.
Okay, that's right, yes, thank you.
I'm consistent, if nothing else, Your Honor.
And we're going to take a 5-minute, oh, I'm sorry, yes, you got a rebuttal.
Hey, if you, Judge,
Afterwards, no,
you're
no.
in charge.
No, yeah.
Okay, I'll tell you what, I'll talk quickly then. 3 quick points.
Take your time.
My colleague mentioned that there must be some deception, and she accused me of relitigating Regina. We're not relitigating Regina, we're relitigating Thornton. In Thornton, there was no deception. Everybody knew what they were doing. Second point, my colleague made a lot of mention about vacancy increases. Hey, we reconstruct it, we take the vacancy increase. We don't know what terms and conditions that first renewal were. In fact, we know from all the other registrations in the building, for people who did renew, they were charged market rate increases. And vacating in response to a market rate increase is certainly rational. So they're claiming we get the benefit of pulling these preferential rents.
But why don't they get that benefit? If the landlord didn't increase or didn't set a rate for a vacant apartment, that's impermissible under the law. Like, why don't you have to demonstrate that? Like, why isn't that fatal to your fraudulent scheme?
It isn't fatal because you don't, for a motion to dismiss, it would not be fatal. If we go in and every one of these tenants, they get a no market rate increase. They increased them to 2% or the 4 or whatever it is. Okay, then that's an issue. But we don't know that, and you wouldn't know that here. All we have to do here is the colorable claim of fraud, and that's what we got. Because we know.
And that's based simply on the rent registration.
Correct.
So that's all it takes to survive a motion to dismiss.
Is showing 387 illegal registrations that the landlord then utilized to take market rate increases? Yeah. That,
Can you address the scheme to deregulate?
absolutely. So, and in fact, it was Justice Troutman who mentioned this in a decision a couple months ago. We give the legislation the broadest possible meaning to enact the legislature's intent. And fraudulent scheme to deregulate, if they had said that it's only if you give them a free market lease and if you put rent stabilized on the top of it, you register it, you can do whatever you want. Well, the legislature wouldn't have solved the Burrows problem. It would be encouraged, that would encourage landlords to file false registrations, which is the whole point of Thornton.
And I may just have this wrong, but at the time this was done in the beginning, was there a possibility you could get luxury decontrol?
No, so this is 421A, right? There is no luxury decontrol in 421A.
And they will decontrol at some point,
Yes.
when the 421A expires.
Correct. So the whole point is to get as much, extract as much as you can. And that gets us back to the argument you said there's nothing egregious here. There sure is. They took $60 million from the people of the city of New York, and they did not follow the law once. Unless there's any other questions?
Would any tenant pay more than they should have?
Yes,
If they had followed the law? I think that's the point.
I'm sorry, if they had followed the law, would it? No, if they followed the law, that's fine.
No, but did the tenants who paid rent, did they actually pay more than they would have if they had properly filed the documents?
We don't know that because we don't know the circumstances on which those tenants vacated, right? Because you don't know, once they start doing this, right, and they're taking market rate increases,
So that's kind of funny to say, I've got a damages action, but I don't know if I have any damages.
you at least have not until you get into this. This is why we have like the RSL code that says you go back to that last registration, right? Because it's the fruit of the poisonous tree. Everything has been tainted by this initial registration scheme. So
I thought the pleading was, we think we are damaged,
we are, because
and we should be able to get discovery to prove it.
Right, well, no, let's be careful here. Once we show the scheme, right?
Yeah.
Then we have two, I'm going to call them statutory formulas, but one's from the rent stabilization law, one's from the rent stabilization code. One says you freeze the rent at the first rent. That's RSL 26517E. And we know once we do that our people were paying more than that. And the other is the default formula that you use and you look at the least expensive rent stabilized apartment. So you don't ever do this recalculation. You use one of those two formulas.
So you get damages, if you establish the fraudulent scheme, you get damages no matter what. in
Exactly
this
right.
case. So the fact that your adversary argued that we were only basing rent increases off the preferential rent and no one was really harmed here is beside the point,
Exactly.
I guess.
Oh, I'm sorry, then why did you say we don't know? When you're asked, are there damages? I thought you said we don't know.
We don't know because it's stemming from that. We know, I'm sorry, and I misanswered the question. Let me clarify. We don't know what the rent would be today had they followed the law the entire
I see.
time.
Because you're not using the preferential rent as your
I got you.
baseline,
Correct.
right?
Understood.
Okay. Thank you very much.
Thank you.